Miss Ellison?
Yes.
You brought this case before the court. What's going on?
Well, I'm divorced from the person that didn't show up.
I see that.
Yes, and I'm here to ask the court for more spousal support. I've went part-time on my job. I'm no longer working full-time. I've lost money, and the man's done nothing but cause me trouble since we've been divorced. He does all kinds of crazy stuff. And I deserve more money with all this harassment, plus I want a restraining order against him. This has to stop. My nerves are on edge. Can't take much more of it. But I think $100 a week extra for spousal support would be fair with all the, the headaches he's given me and everything like that.
Hey everyone, welcome back to the channel. Today we're taking a deep dive into a dramatic courtroom case from All Rise Support Court with Judge V. The case, labeled JVB 1073, features Miss Ellison, a divorced woman seeking additional spousal support from her ex-husband. But did she really have a solid case? Let's break it all down. Miss Ellison brought this case to court claiming she needed an extra $100 per week in spousal support. Her main argument? She had moved from full-time to part-time work and could no longer afford her expenses as easily as before. On top of that, she alleged that her ex-husband had been harassing her, stating that he drove around her home honking his horn in the middle of the night and even showed up at her workplace unannounced, causing disturbances. Judge V took the harassment claims seriously, but pointed out that restraining orders are not issued in this particular court. Instead, she advised Miss Ellison to seek legal assistance through the proper channels, such as filing with the local police department or another court that specializes in protective orders. This is an important distinction because different courts handle different legal matters.
Okay. You said you believe $100, an extra $100 a week is fair.
Yes.
Why do you believe that's fair?
Well, like I said, my wages have went down. I'm only working part-time now. We're doing layoffs and things like that. So
you said your wages?
Yeah, my wages.
Okay.
Are going down, and his are going up because he still gets those 2 raises every year. He's been with that company forever, and he makes good money. I don't make half of what he's making, and it's been really tough. I raised his children, I entertained his friends, I kept the house clean, I did everything that a good wife does. I think I deserve that extra $100 a week.
Now let's move on to the financial aspect of the case. This is where things get interesting. Miss Ellison was already receiving $325 per week in spousal support. Additionally, during the divorce, she was awarded the marital home and received half of her ex-husband's 401k, a sum of approximately $250,000. Despite these assets, she argued that she deserved more money because her ex-husband continued to receive raises while her own income had decreased. At first glance, this might seem like a reasonable request. After all, if one person's financial situation improves significantly, shouldn't the other party receive a fair share?
And he can certainly afford it.
What does he do for a living?
He's a CEO for an oil company.
Okay.
Yeah. Makes really good money, bonuses and all that stuff. I mean, he's just raking it in.
How much is your spousal maintenance right now?
The spousal maintenance, it's about $325 a week maybe.
Okay.
He doesn't pay on time either. It's not always on time.
However, the law doesn't quite work that way when it comes to spousal maintenance. Judge V made it clear that spousal support adjustments require a substantial and legally justifiable financial change. Simply put, just because an ex-spouse is earning more money does not automatically mean the other party is entitled to a bigger payout. In fact, after reviewing the details, it became clear that Miss Ellison's financial situation had not worsened significantly. If anything, her expenses had actually decreased. She owned her home and had minimal payments left on it. She had no car payments, only routine expenses like utilities, gas, and groceries. While she claimed that entertainment expenses should also be taken into account, the judge was firm in stating that spousal support is meant to cover necessary living expenses, not leisure activities. Judge V then asked Miss Ellison about the 401k settlement she received in the divorce. This was a major turning point in the case.
What type of expenses do you have?
Well, I have rent. I'm still making the payments on the house. Before we got divorced, we had it redecorated. Carpet paneling on the outside, siding on the outside, all kinds of different things were added to it. And I'm making the payments on that still. I still got another 5 years for all those payments to be paid off.
When asked how much she had received, Miss Ellison admitted that she'd gotten about $250,000. That's a substantial amount of money that should have been factored into her financial planning. Judge V reminded her that this amount was already considered when her spousal maintenance was initially determined. Since the original ruling had taken her financial share into account, she could not ask for additional support based on the same factors. At this point, it was becoming clear that Miss Ellison was not providing a strong enough argument to justify an increase in spousal maintenance. Judge V stood firm, explaining that if the court allowed raises in support payments simply because one party's income increased, then countless people would flood the courts with similar requests. The system must remain fair and consistent, and in this case, there was no legal basis for a modification. In the end, Judge V denied Miss Ellison's request. She stated that spousal maintenance isn't about continuously adjusting payments whenever circumstances change slightly. It's based on legal guidelines that ensure fairness for both parties. Miss Ellison had already received a significant portion of the marital assets, including a home and a large 401k payout. While she may not have been happy with her financial situation, there simply wasn't enough evidence to support increasing her ex-husband's payments. So, what's the takeaway from this case?
This is Texas, which is a community property state, so I'm assuming you at least got 50% of that.
Yes, I did, but
Yes,
I don't think
no,
that
ma'am.
should be taken into consideration.
No, ma'am. It was taken into consideration the first time you received spousal maintenance. You can't have me take it into consideration again. That's not fair, and it's definitely not the law.
His 2 raises every year. I don't get raises. My job's a very poor paying job. I'm uneducated. I mean, I'm not, my age, I'm not going to find much now. I have to stay where I'm at. I feel like I'm trapped in this life.
If you're seeking an increase in spousal support, you need to present a strong, legally justified argument. The court will not grant additional payments just because your ex-spouse is earning more money. You must demonstrate a significant financial hardship or an unexpected life change that affects your ability to support yourself. Additionally, if you're dealing with harassment from an ex, it's crucial to take the proper legal steps by filing a restraining order through the correct channels. Now we want to hear from you. Do you think Miss Ellison had a valid case, or do you agree with Judge V's decision? Let us know in the comments. And if you found this breakdown helpful, don't forget to like, subscribe, and hit that notification bell for more legal insights. Thanks for watching, and we'll see you in the next video.
And Miss Ellison, I feel like you came here to waste my time because I cannot give you an increase in spousal maintenance just
$50
because
a
you're
week?
asking for it. No, ma'am.
25?
Even $5, the answer is no. Let me ask you this question. When you all were divorced and you received half of his 401k, how much was that?
$250,000.
Okay, well, you know what? If there's nothing further, your case is dismissed and so are you. Thank you.